Heyo, 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 heyo. Oh, Jesus. Yeah. Hey, welcome to today's stream about the November. It's a hearing. Young Thug RICO-trial is scheduled to start November 27th, but there has been a lot of hearings the past week because Prosecution, they try to enter new evidence all of a sudden, and the judge went mad. That was the other day, and there's been a lot. There's been the lyrics are somewhat coming in, but they have to get approval each time with a 403 hearing, or each time they want to put in a lyric into evidence. And yesterday, the defense managed to get some evidence out, and the prosecution really didn't like that. They tried to cut them off, and it was a cluster F. So today will be really, really interesting to see what will happen now. And of course, Law and Seward started late and mid-sentence. But I take what I can get. So here it is, and let's get the tractor up. Boom. Or should I do one of these? One of those. Okay. And as you see, this is... They are already up and going at it when the stream starts. But here we are. I will try to get to guide you through this as much as I can. And but yeah, here we go.
By the way, you're on. May I approach 1 second? Yes. This is Fred Mark. I'm moving them for purposes here. That's Mr. Williams, number 4. I noticed I quoted it for Ms. Love statements that I read into the record. Okay, so Discovery 13 has total new material on Tierra, T-I-A-R-A Jones,
J-O-N-E-S, homicide. This
Pierre
includes,
Jones?
yes.
Okay.
All new material. This includes a 97-page ATF ballistic information report. This includes 5 new discs, gigantic discs of information on Hassan Pope's case, Hassanpope. This includes the investigative Crabtree geofence Google targeted Mr. Williams' phone. I have no report. I have no legend. I have no explanation. But I did speak with Investigator Crabtree, and he told me it was exculpatory to Mr. Williams. But all I have is a drip, and I just want it out for the state, and I'll use it for myself as exculpatory evidence. It has Act number 173 through 176, and when I say
Wow,
Act, it's overt act.
You said what? Act?
It's count 1, RICO conspiracy, then overt act 173 through 176.
Oh,
These are 3 body cameras.
this supposed case he's talking about, I believe, is a 2017 case, and which is a part of this RICO trial, and he just now got exculpatory evidence regarding those charges. I mean, the trial starts in 11 days. They have been at it for, over a year. And now, 11 days before trial, he gets his hand on some exculpatory evidence, or evidence that might point to innocence. 11 days. This is the prosecution trickle-truthing with the evidence, with the discovery. They are trying so hard to avoid giving the defense a chance to defend their client. But at least it's out. And yeah, let's continue.
Dated March 13th of 2022. This is before the indictment ever rang out. We're getting it for the first time.
3 March, you said what?
March 13th, 2022. Tiffany Zachary, Zachary, on Waters Road. It's the first time I see it, and these are body cameras.
That would be up to the judge to decide.
From City of Atlanta police, dated before the arrest and indictment. We're just getting it on October 5. The next is GBI report, Firearms 5. It's dated July 28th, 2023. Cartridge casing comparison. Mark Tanner is the Tanner, T-A-N-N-E-R, is the analyst. The Discovery 12 did have GBI firearms reports, but it had 1 through 4, so this added the 5th one. This has Georgia State Patrol Trooper M. Campbell, C-A-M-P-B-E-L-L. This is a pursuit on March 17th of 2022. Then you see the gun in the road, goes back to retrieve. I just got that.
Didn't we have a hearing on that already?
Yeah, I just got it.
And we also saw the video.
Yeah, it was served October 5th. That's exactly right. March 6th, 2022, Instagram post of Waters Roadhouse shooting video. I just got that. March 7th, 2022, Instagram postings of Jeffrey Williams at Waters Road.
When was that again?
March 7th, 2000.
March 7th, 2022. That's, what is it? Over a year and a half ago. They had it. And he got it now. For me, if I become an almighty judge of sorts, I don't know. Discovery for the defense and especially potential exculpatory evidence, should be released immediately. If you wait to 11 days before trial, why? In my opinion, prosecutors have unlimited resources and they still cheat. That can't be rewarded just because, oh, we want to leave it in the hands of the jury. No, in my opinion, if prosecutors conduct themselves this way, they should lose the entirety. Just, I mean, a drop kick out of the courthouse. Thank you for your interest, but we can't have it this way. That is pissing me off.
22. I just received it on October 5. There's a music video, Beast Slime Separation, shot at Waters Road, released on March 24th, 2022.
Heyo.
There is phone dumps. I can't get through them from Mr. Eppinger and Mr. Beebe. I'm trying to analyze them.
And how many of those are there?
2, Mr. Eppinger's phone and Mr. Beebe's phone. They're giant.
How big?
Oh, God. Phone dumps are, I can't even, it takes us months to go through phone dumps.
And when did you get, and those are from when?
October 5, 2023, we were served with it.
What phone, when were the phone dumps done?
Hold on.
There's a difference because the phone dumps were done in the fall or something like that, or actually gotten in the fall. That makes a difference to me.
Let me tell you. Hold on 1 second, okay? If that's okay, can I step away?
Can you find that information, please?
So the phone.
And Mr. Nye, on the look, Your Honor, can I just?
No, I'll pause.
Can we pause for that?
Hey, things stand. Hi, the sock snatcher. Hello, Kim, Brooks, Melissa, Mike, Al, and everybody else who is here. Hit that thumbs up. Yeah. You know what you're supposed to do. And let's get pissed off at this. I mean, even if they got a phone dump a month ago, yeah, but a phone dump. As he said, a phone dump takes months to process. Okay, which, where, what, when, who, what's going on, which phone numbers, which data is on it, which GPS data. I mean, that stuff takes ages to prepare for. And yeah, let's continue.
Mr. Renard said she's looking for it actively.
Hi, Sonny. Yeah, I mean...
Ms. Love, do you know what date that is?
Your Honor, that's what I'm actually asking a colleague. I will get that to the court in just a moment.
All right, okay. All right, so you're gone about 40 minutes. Wrap it up. I got 5. You got less than 5 minutes, okay?
All right, well, to answer your question, the drinks murder, jail calls from Mr. Jackson. Those are in March 17 to 23, 2022. Mr. Nichols has jail calls.
So you got the March 17th drinks murder, those phone calls or what?
They're just jail calls, but I don't get
How many
any.
jail calls are we talking about?
10 for Mr. Jackson, 3 for Mr. Nichols. This is gigantic. Mr. Williams' social media. I have now to go through tweets from 2011, 2012, all the way through.
They weren't provided before?
Right. And I'm telling you, it is huge.
How big is the file? How many documents are we talking about?
Millions.
That many?
Millions. I'll get you the number though, because that's on the screen.
Yeah, Mr. Young
I need to know that.
avid tweeter.
There's another phone dump from Mr. Ryan. Shannon Stillwell's phone dump. Mr. Kendricks has 8 transcripts now. I'm getting reports from Detective Gaither that go back to 2015 on Mr. Garlington. There's new Operation Planter sideshows that go back to 2015. There's now another huge file of Mr. Williams, not Twitter, but Instagram account from 2014 to October 2021.
Give me the Instagram again.
2014.
2014 to what?
To October 2021.
And how many pages are we talking about in terms of that?
Million. I'll get you the, because that's imprinted on the, and there's more. Your Honor, answering, in the limited time that you're giving me, if you just understand one thing, and it's captured in Malaguti, Malaguti versus State, it's 273 Georgia, 398, 2001 case, Georgia Supreme Court. It's on page 5 or 6. It's footnote 9 of the case that I printed out.
Which one are you talking about, sir?
And the parties, Malaguti, Malaguti.
Yeah, when it comes to information dumps that large, I hope that the Georgia Supreme Court has an opinion about it. That's
what page?
5 or 6. It's footnote 9. It's at the very bottom right. Our High Court explained that contrary to Malaguti's assertion, the trial court did not conclude that the state's delay in disclosing that Anguin, A-N-G-U-I-N, would be a rebuttal witness was prejudicial to Malaguti within the meaning of 17-16-6. Instead, the trial court simply stated that Malaguti would be prejudiced by Anguin's testimony. And this is what I stress. The finding of prejudice that is required by Section 17-16-6 in order for a trial court to prohibit a witness from testifying is not the prejudice that is inherent in the testimony of any opposing party's witness. Instead, the prejudice must arise from the failure to comply with the discovery statute. That's what I'm saying. Your Honor, when you say, hey, file a demand, and they're trying the best they can, there's no evidence they're trying the best they can. They had this evidence in June of 2022, ready to go. Instead, I don't get this evidence until October, some of this. In addition to that, this honorable court, bad faith, I can't get over the do not serve yet. Do not serve discovery yet, which I alluded to before. It's in here. I attached it to the motion.
They responded to that particular issue in their response.
Yeah, so they wrote, I think that's absurd. They wrote, it wasn't done intentionally because we would never have left the logo on it. That's pretty insulting. Why didn't we get all of this discovery when required? So those are,
Yeah, I agree with you, Atheist, that if discovery hasn't been shared with time to review for the defense, it should be a mistrial with prejudice. But well, it's sort of, because this is one of the first RICO trials against a gang or supposed gang in Georgia. And the RICO statute is very, very vague. And it involves alleged crimes from 2012 to 2021. 9 years worth of alleged crimes. Some of it I've covered before. in previous streams about them trying to get in crimes that wasn't prosecuted at the time because they had no evidence. But now in RICO, they are in mass putting on charges for everything and the kitchen sink with the same lack of evidence, but the sheer volume they hope will convict them.
I have 308 new witnesses that I'm asking to be excluded. And I'm asking also Mr.
You said 308 new witnesses?
Yeah, that's what happened. It doubled. It doubled.
Are those, any of those witnesses, were any of those witnesses on any of the materials you provided in
Yes.
Discoveries 1 through 12?
Yeah.
Okay, well, how many new witnesses that you didn't, that are new in 13?
I have to get back to you. There's a lot, but I have to get back to you. But there's a lot. You know, all that discovery I mentioned, and there's a lot more. All that discovery is new. And I'd like the court, you asked me this previously, you know, to announce what questions I have for the prosecution, put in writing for the court. And I put that in my motion.
I got
And
those.
I can't get over, you know, I followed the rule. I gave a witness list, as best witness list I could with current numbers, all date of birth, all addresses. The state had its obligation to do that. And what gives the state the right to decide when we got discovery, when the statute says you get discovery before trial? And it was ready. Don Geary, 97% ready.
Yeah, remember, trial start usually is when they start to assemble the jury. Usually. I'm not sure about Georgia, but so these are all, I call it pre-trial motions, but they are motions hearings in wait for the actual, what we call trial to start. But you heard it in the Melly trial in Florida, that they had 60 days to refile to start the trial. And there they count when they start with the jury selection. That is when they say the trial starts. And if this is the same here, then that started in January of this year. And not until now they are getting all this material, all these disclosures, all these, and additional 380 witnesses on top of the close to 400 witnesses that was already in this trial.
So I understand what you said about time. I have a lot more case law, but I gave it to this honorable court.
And I appreciate that. I was able to look at it.
I appreciate you. And you know, I appreciate what you said, that if this was a civil case, it would be easy and you would exclude it. And I appreciate that. But to me, and I've never been a court, but a civil case exclusion seems, I don't know, it doesn't seem as important in a criminal matter. I mean, I have a duty to go and interview. You would tell me, you would order me to interview every witness. I can't do that. So what can you fashion, you ask, if you're not going to exclude everybody? Courts, and I have the cases for you, courts have said, okay, then the remedy is, and it's Muse, you're going to interview all the witnesses. The state is I'm requiring the witness to be interviewed by you. It's not up to them anymore. The state puts you in this position. I have cases to support this I gave to the court and the parties. They will meet with you. I'm going to designate times and dates. The state will not be there. It's not an interview where the state can sit there with you. It's just like if you were out there and interviewing them. And if they won't speak with you, there are exclusions. I'm ordering the witness to speak with you. If the state can't get the witness to speak with you, then you come back to me. There's another case, and I'll give you the name if you're interested in it, that says that the court sat with the parties and made the state sit there and say, who are your real witnesses? I'm not making them go through all these people. I want the essential witnesses that you're really calling. Tell me what they stand for, and then we're going to designate a time that the defense can meet with them. And if they can't do that, if that doesn't happen, they can't testify. There's another case that holds the proposition that that the state has to say with particularity who they're calling.
Now, he asserts that there are case files on this, what he's claiming. I would wish he actually had them there. But as it seems, he has to do this on the go because the prosecution just gave him discovery, including 380 new potential witnesses. 11 days before trial. In his lap. Twitter dumps spanning from 2011 or 2012 up until 2020. 8 years of tweets. Instagram, 2014 to 2020, 6 years of Instagram. That's, and I'm not an avid tweeter. I have no idea how many tweets I have. Let's see if I can see that somewhere. Yeah, I have no idea, but it's definitely in the thousands. Yeah, I know my internet is choppy. I will change to mobile internet. Okay, I changed from router to mobile. I hope it improves a bit. Oh, Sonny, thank you so much for your aid in the Adelson trial. And yeah, I do my best. I'm learning as well. But the RICO statute in Georgia is amazingly vague. Amazingly vague. And that is one of the reasons why I wanted to cover this. To learn myself and to pass on what I've learned to you guys. And as I said, I'm not an avid tweeter. I maybe do, some days I don't. Some days I have 20, 40, 50. It's all depending on if I have something to say. But in the years I've been tweeting, it's thousands of tweets. And I would assume that a rapper tweets a lot more. And he just got everything. 8 years worth of tweets in his lap. 6 years worth of Instagram posts in his lap. And he's supposed to go through that in 11 days? It's so infuriating.
And you already ordered that. We were supposed to get 2 weeks before who they're calling. That just helps me to know which witnesses to try to run in like an ant with a crumb and try to interview. The state just shortened it a week and the holiday week. I don't care. I'm here. But, the 2 weeks is already gone. So, and I wanted more than the witness name. I wanted the exhibit, the document, the photograph, the video, just so we can be prepared. And that's what everyone wants. You know, nobody should be rooting for anybody being unprepared. That's I have all those cases, and you have them too, but I could show you exactly where they are.
Which case did you, I'm particularly interested, you cited for the proposition to require the witnesses to meet with you.
Yes, sir. GCICs.
Okay.
I also asked for, obviously, GCICs.
I also want to know the case you're citing for the proposition, who your real witnesses are, who you're going to call.
Let me,
I like those two cases.
yes, sir.
Should have had an assistant for that. Hey, Jolie. Good to see you. Yes, and Atlanta, Georgia. I don't follow rap music that much, but I believe what you say. Yeah. Where's the and what is the searching for it? One of the supposed lyrics, there was a tweet about it that Nicki Minaj claims to have wrote that lyric for Young Thug, which they want to use in this trial against Young Thug, as this is proof of gang affiliation, gang wording, and yeah, it's so stupid. Don't know if it's true, but that was the tweet.
RRIS. Your Honor, it's Norris, NORRIS, versus State, which is 289 Georgia, 154, 2011 case. And on the printout that I've given this honorable court and the parties, yeah, it's on page 3, 2 of 6, going into page 5 of 6. Specifically, Your Honor, the court wrote, this is the highest court in our state, on page
Yeah, I mean, almost 800 witnesses. If they get through 4 witnesses a day, that's 200 trial days. That's more than 6 months. We are going to be here for a year and a half if the prosecution keeps piling on stuff.
3 of 6 on the top left. In the first line on the right, the Honorable Supreme Court of Georgia.
Yeah. For you who don't know, Georgia RICO Act is the same RICO Act they are using against former President Trump. I don't follow that case. I think Joe Niederman is covering that case.
So what page is on 3 of 6?
Yeah, yes, sir.
All right.
The first line, Your Honor, at the right-hand side says, it appears that Norris was aware of all of the witnesses' identities except one and knew of the state's intention to call many of them as witnesses. And I'm skipping the cites. However, the discovery reports here did not contain sufficient contact information in several instances. And it goes on, it's great language, but I'm skipping to the right-hand side, first full paragraph, little above the center. And I'm reading, Your Honor. At a pretrial hearing on June 12th, defense counsel moved for a continuance pursuant to OCGA 17-16-6. Instead of granting that motion, the trial court directed the state to compile a list of essential witnesses whom the defense counsel would be permitted to interview after jury selection. The trial court discussed each witness on the shortened witness list with the parties. Some were excluded, and defense counsel waived any objection to many others. As to the 2 witnesses who were not listed in discovery, Norris's attorney agreed to a limitation on the testimony of one and was already aware of the other, seeking to exclude her testimony only on relevance grounds and not because of surprise. The trial court ordered the prosecutor to have certain witnesses available for interview on June 15th and expressly recognized that the state had problems, presumably previously specified difficulties with furloughs and reassignments of the case to a new prosecuting attorney, and that the prosecutor was doing the best she could. Late in the day on June 15th, after jury selection, 3 of the witnesses were unhappy with being delayed, did not want to be stranded without a ride, and refused to be interviewed, even though the trial court had apologized and explained that the need for their presence was attributable to the district attorney. When the trial court was informed on the morning of June 16th of the witnesses' refusal, the prosecutor noted that they were again present, but could not be compelled to be interviewed, and that the defense counsel could proceed with interviews of anyone who was willing to speak. Norris's attorney said nothing, and Armour's A-R-M-O-U-R, lawyer agreed that they could not be compelled and stated that the true remaining issue is the untimeliness of the state's witness list. The trial court said, okay, let's bring the jurors out. We're starting the case. Neither defendant voiced or made any further objection. The witness list rule is designed to prevent a defendant from being surprised at trial by a witness that defendant has not had an opportunity to interview. Defense counsel attempted to interview the 3 witnesses in questions on the first day and declined to seek another such opportunity despite the state's invitation to do so early on the second day. Although Norris had the opportunity to interview the 3 witnesses prior to opening statements and initially attempted to do so,
I read it. Okay, so what's the other case you're citing for the proposition of who your real witnesses are?
Say it one more time.
Which case are you citing for the proposition of who your real witnesses are and who you're calling?
That was it, the essential witnesses, and break it down.
Are you saying Norris is for those 2 propositions?
Yeah, and then who you're calling in order is for fairness.
I'm sorry?
It's for fairness. I mean, who they're calling in order. What are we going to be blind here? This gigantic trial, and I'm just going to show it with witnesses, and I have to say, Judge, I haven't interviewed the witness because the state didn't give it to me on time.
All right.
Okay. The phone dump.
Yeah, information on the phone dump. First one is, let's see.
Yeah. Something in this, I mean, the judge has his rules to abide by, and he has, well, he can, if he wants to, go for, okay, I'm sick of this, try to appeal for it, but I'm throwing you out. He could do that, but he's not. And this is something that is called in the interest of justice, that a trial should, trials should be, it should be up to the prosecution to have that self-awareness, and that a judge don't want to take that away from the prosecution. But in this case, through everything I've covered for the past 6 or 7 months in this trial, yeah, I would almost agree it seems like a kangaroo court, because giving the prosecution this much leeway it's saddening for our beliefs in the justice system, that prosecution can wait a year with discovery and just put it in their laps less than 2 weeks before trial.
I don't have the names.
I think it was one after March the 21st of 2022.
I
You
just have,
said there's 2 phone dumps with Evinger and Beebe.
I just have, and I'm not sure this, I need to look at my information, but I have January 13, 2023. But
January 13th, 2023, they were provided to you? Or
No.
They were, that's when those calls were, that's when those calls were, or the phones were dumped?
that's my understanding, but I have to get which phone.
Okay, and how much documents are we talking about? Or cell phone records?
How much? One what? I understand, but the judge is asking, what is the terabyte?
Like, is it a terabyte? Is it how many documents or how many pages?
I have that, so I can get that to you.
Well, I need to know hard numbers, Mr. Steele. So
Okay.
when I recess in a minute, I need the hard numbers for that. I also need the hard numbers for the social media postings from 2012. Make sure. Can't read my own writing. I'm sorry. I think you said 2009 to 2011, 2009 to 2012. Is that the one? Is that the Mr. Williams' social media pages? They had millions of documents. Is that the correct time period?
Let me tell you. 2000 for the Instagram?
Well, I had that. Instagram, you had Instagram. That's March 7, 2022.
Instagram I have from 2014 until October 2021.
2014 to October 2021. That was it. And that's the one you said you had millions of documents.
These are huge, yes, and I'm going to
Okay.
get you that. And the Twitter was from 2011, starting in 2011, and it's also gigantic.
Twitter is from, and how many pages are we talking about?
That's what Miss Renard, otherwise when I sit down, I will get that for you.
Yeah. When the court does its recess, he always says 15 minutes, but it can almost always it's an hour, and I don't know why. So once they go to recess, we are going to interject with yesterday's hearing, because I heard that was quite spicy.
The phone dump, I'm being told, is 2.52 megabytes.
Which phone that you're on?
Megabyte.
I'll let you know. I'm not sure which one.
Yeah, which phone dump are we talking about, Ms. Renard?
2.5 megabytes can't be the number. I mean, I have photos larger than that.
Brother, I don't know whose phone it is.
I'll get that for you, Judge.
I'm sorry, what was the last thing you said? Discovery what? I apologize.
Say Discovery 13, but I do not know who started this.
All right.
We will, seems like fairness is subjective.
And if there's no consequences, then I guess it almost rewards the conduct. And what I can't get over for bad faith is that the state knows that the trial started, they know the statutes, and they just decide on their own that they're violating it. And the prejudice is because I don't have, until September of 2023, I do not have valid phone numbers, addresses, and date of births on almost every state witness.
And you didn't get those, I'm sorry, till when?
September 2023. You know, I got to run GCI systems. I don't run them, as you know, like the state. I have to go pay for it, wait to get it back, then analyze it, and then go get certified copies. This is
Yeah, that sounds like the prosecution, because these lawyers get paid $15,000 for the entire trial. And all of a sudden, he has to, for the witnesses, he has to pay out of pocket to get certified copies, takes his time for it. I mean, this is in my opinion, this is the prosecution trying to bankrupt the defense attorneys.
Respectfully, this is really wrong.
So I think we're going to take a,
Okay.
if you complete your argument, I've given you over an hour. I think that's been more than.
I have more, but I'm going to respect the court.
Well, I'm good, Mr. Steele. I think I got more than the gist of your argument, and this is not the first time that you have. Yeah, but I appreciate you fleshing it out for me in terms of where your position is, what you cited in the break. I do need to find out the Instagram post from Williams from 14 to 21. I want to know how many documents we're talking about. I also want to know the phone dumps that you got on there from January the 13th of 2023.
It should not be hard to do that.
All right. And I want to know the Twitter universe of Mr. Williams from 2011.
Yeah. The bare minimum. If Mr. Williams put out one tweet a day for 9 years, that is 3,285. Now, I don't think he put out only once a day. Maybe 10 in average. All of a sudden, we have almost 33,000 tweets. Say he put out 20 tweets. Well, all of a sudden, we are getting close to 70,000 tweets in 9 years. Instagram, did he post once a day, twice a day, 5 times a day? And all that is in data dumps, where not only here's the tweet, here's the time, might be a location, what device, stuff like that. So there could be very well be one document per tweet. And let's say he got in a week-long Twitter fight with other rappers. I mean, I don't tweet much. But if I get into a discussion, I can have 200 tweets that day. Oh, hi, Nikki. Yeah, I know people don't get notified. YouTube is not fun. People who... I heard this from another YouTuber that YouTube only sends out 25 notifications to 25% of the people who asks to be notified. But the more notify all the bell thingy, at least you have a chance to get notified. And I try to put it out on Twitter, on Discord, on my Facebook page, if you're old enough to have one. Yeah. This is so infuriating.
Okay, understood. All right. Ms. Love and Ms. Yahowski, you all can collect your thoughts. We'll come back at 11 o'clock. I'll go ahead and continue arguing. I'll have your argument at that point in time, okay? Thank you, sir. All right. Okay, we're in recess. Go ahead.
Okay. Ahead, and they are still not back. So what I will do is we go into yesterday's, because I heard this hearing was heated. And as per usual, the coverage starts mid-sentence, and it is gray hair man with ponytail, lawyer.
Exhibit is covered in notes, scribbles, and just in the first few pages, highlights. And so to the extent that it's, been altered, we also have that objection.
Hold on. Let's do one of these first. Dun, dun, dun. There. My Norwegian firefighting dragon is my swoop.
Ms. Harvey, I'll admit it is D1, but you need to give us a clean copy, so for purposes of later.
There's only one page with the highlight. The copy is exactly as it is in the archives of the state of Georgia. These come from the revolutionary records of Georgia, lots of which have been lost, and you spend days in the Georgia archives gathering this information. So I'm glad you changed the one page with a highlight on it.
All right, D1 will be amended for purposes of motion.
All right.
We start with the proposition that in the state of Georgia, during the period specifically mentioned by Bruin, that is applicable to the federal government and states, is pegged to the public understanding of the right when the Bill of Rights was adopted in 1791.
Oh.
So from 1791 to 1802, at least as far as these records are concerned, there was zero prohibitions in Georgia law. The first prohibition in Georgia law was litigated in Nunn versus.
He went way back with this. He went way back with this. Jesus.
This is a state at 1 Georgia. The first volume of our reports, 1 Georgia 243, pinpoint site at 251, that's 1846, and it is dealing with an 1837 statute. We are of the opinion then that so far as the Act of 1837 seeks to suppress the practice of carrying certain weapons secretly, that it is valid inasmuch as it does not deprive the citizen of his natural right of self-defense or of his constitutional right to keep and bear arms, but that so much of it as contains a prohibition against bearing arms openly is in conflict with the Constitution and void. So we're starting in 1846 with, even though there's not a constitutional provision at that time in the Georgia Constitution, that the Second Amendment applies to Georgia, and it cannot prohibit, now this is the catch, it cannot prohibit a citizen.
I did not expect to have to hear about a Second Amendment motion here, but here we are.
From carrying a weapon. Now, what's the catch? What's the catch there? The catch there is that immediately after that,
We will hear him out, and then we will go back to November 16 hearing.
the Georgia, let me see, I don't know whether it was the Georgia Court of Appeals, or the Georgia Supreme Court, hold on.
Speed it up a bit.
By a joint resolution of the legislature of Georgia in 1842, it was unanimously resolved that the free Negroes are not citizens of the United States and that Georgia will never recognize such citizens.
I did not expect to hear that word. Oh, crap. It was nice to know you, audience. YouTube, that wasn't me. That was from the court, from a legal statute. YouTube, do you hear me? I didn't say that. All right. I did not have that on my bingo card today. I did not have that on my bingo card. Well, that's good news.
So that what they said and done applied to citizens, but not the people that they determined would not be citizens and never could be citizens in the state of Georgia. So the basis for those type of early prohibitions, if there were any, were strictly rooted in racism. And the court in Cooper versus Savannah at 4 Georgia 68 said as follows: free persons of color have never been recognized here as citizens. They are not entitled to bear arms, vote for members of the legislature, or to hold any civil office. They have always been considered as in a state of pupillage and have been regarded as our wards. And for that very reason, we should be extremely careful to guard and protect their rights, but no other rights like hold any office or bear arms. Indeed, with regard to the white male population, Marbury's Digest of the Laws of the State of Georgia, the Act of December 24th, 1792, allowed that all free, able-bodied white male citizens of the respective states resident therein who is or shall be of the age of 18 years old and under the age of 45 years shall severally and respectively be enrolled in the militia. The act exempted certain classes of people, but not felons. That is to say, there was never in the state of Georgia a prohibition on convicted felons possessing or having weapons. In fact, the statute at issue was first passed by the legislature in 1980. So if we are looking to the historical roots of the constitutional recognition of the Second Amendment rights in the state of Georgia, there was never a prohibition until 1980. There was never a prohibition during the relevant revolutionary period, and any prohibition was specifically related to race, in pure race.
Okay. Yeah.
So that's the history in Georgia.
Yeah. This is about a gun that was found in Young Thug's car. That one of the passengers said, "Oh, those are mine." But on a body cam, Young Thug may or may not have said, "I've had that for years." So they are trying to exclude that evidence with a really, really old statute.
So where are we with regard to any any inquiry nationwide? And good question, you said. Okay, here's what I said. For the record, let me tender defendant's exhibit number 2, even though I have no burden, and I'm not accepting a burden. It is a 56-page survey that I have prepared of what I believe to be all the relevant statutes in the United States of America with regard to any firearm regulations. That's from pre-founding, the year 1383, through the year 1888.
Was it done? Was it done? No?
D2's admitted.
Thank you, sir.
All right, D2's admitted for
No
purposes.
objection.
D2's admitted for purposes of the motion.
So we have surveyed for you every piece of Georgia legislation related to firearms up until the 1980 first provision prohibiting felons in possession. We have surveyed for you every available known prohibition, or not prohibition because there were no prohibitions, every known statute from the pre-constitutional times to 1888. And I believe that what we show is the following. With regard to any prohibitions with regard to the ownership of guns, between 1607 and 1815, the colonial and state governments of what would become the first 14 states of the United States neglected to exercise any police power over the ownership of guns by members of the community. These limits on colonial and early state regulation of arms ownership outlined a significant zone of immunity around the private arms of the individual citizens. And again, I use the word citizens because there were clearly prohibitions on religious groups. There were prohibitions on insurrectionists. There were prohibitions against people of color. Those were the prohibitions. But as Bruin says, quote, apart from a few late 19th century outlier jurisdictions, American governments simply have not broadly prohibited the carry of commonly used firearms for personal defense. And personal defense is what is at the core of the Second Amendment. I think the survey.
But personal defense for law-abiding citizens.
No, personal defense for anybody.
Well, it seems to exclude people who have been convicted of felonies.
Who? What? What statute?
By the state.
What statute? Tell me what statute. I have heard.
Statute 1611, 131, 133, right?
Yeah, but that's in 1980. We're looking at 17.
Why are you going back and dredging up all the other things about race and the obvious? Okay, what does that have to do with anything that we have that the legislature? Not that it's not interesting from a historical perspective, but what does that have to do with the Georgia legislature in 1980 then deciding, well, we're going to prohibit felons from having weapons?
Because that's way outside the historical analysis called for by Bruin. 1980,
Yeah, but
the law wasn't passed until 1980.
I'll give you that. But Georgia has enacted a series of these two statutes, which they've taken the historical perspective. Haven't they?
No.
Then
Who
why do you
has?
say not?
Who has? Tell me where they've taken the historical perspective.
In enacting the statute, what is the have you taken a look at the legislative history of these two statutes?
I'm not obligated to.
I'm asking you as an officer of the court. Have you taken a look at the legislative history
Have
of
I?
these two statutes?
Yes, and the same.
What do they say? What do they say about? Usually, our legislature, when they enact a statute, they have some legislative history. They talk about the reasons for the enactment of a statute. You're asking me to have an academic discussion with you right now, so I'm having one with you about what did our legislature in enacting this particular statute, these two series of statutes, say about why it is that they were going to go ahead and do that?
Because I think they saw a general societal problem. And
That problem was?
And that problem was firearms.
In the hands of?
I beg your
In
pardon?
the hands of?
In the hands of people that have been convicted of a felony.
Okay.
And you're correct. I'm not arguing that isn't what happened in 1980. What I'm saying is that the Supreme Court says what happens in 1980 doesn't make any difference. They specifically say that. And the same thing with the federal government. The 922G1, which is the federal prohibition against possession of firearms by a convicted felon, didn't go into effect until after 1938. And that's one of the bases that the Rahimi court said, hey, we can't look at 1938. We're not here to resolve societal problems. We're here to determine what the Second Amendment means. And we say, here's what it means. It means what it says in 1791 when adopted by the people. And the importance of my historical analysis is that there were de facto prohibitions, and those de facto prohibitions were related to race and religion primarily. And as far as I can tell, there were no gun laws in the northern states for 50 years. As far as I can tell, there were no gun laws in the southern states for 50 years. And the one prohibition that was cited in Heller, and the one decision that was cited in Heller, was our Nunn versus the state, saying that the 1837 statute was unconstitutional. So history is what this is all about. I'm not arguing with you about the modern day reasons. I am saying that under the specific historical test in Bruin, that the state of Georgia's prohibition, Johnny come lately in 1980, the federal prohibition, Johnny come lately in 1938, neither one of which passes the Bruin historical. We're looking at what the people believed when they adopted the Second Amendment in 1791. And I'm sorry, but
But isn't that what range seems to talk about? It talks about, well, neither of the courts have offered a workable test for identifying
This is very
the
interesting.
application of section, is it 922G1?
yes.
All right, so, okay.
Well, you say, okay, I'm saying, okay, the state hasn't met its burden because
Let's 5 more
this
minutes.
particular amendment in the Georgia
we'll
statute
go back
and the Georgia
to
Constitution
page,
prohibits conduct, not status. Any status-related prohibitions during the founding era, during the adoption era, were not prohibitions on the possession of weapons. Weapons could be confiscated, but there was never any prohibition, and I haven't heard a single statute, not a single statute.
Okay, but all right, let's assume that you're correct. Wouldn't this be something for the legislature to take up?
I beg your pardon?
Wouldn't this be something for the legislature to take up?
No, because, and let me tell you why. Well, I guess it could be,
Well,
but,
I mean,
but,
look, because the case that you gave me, Range said, you know, I'm quoting from Range now, unlike an administrative agency, courts possess neither the resources to conduct the requisite investigations nor the expertise to predict accurately which felons may carry guns without threatening public safety.
well, maybe.
I mean,
But they're saying the statutes
they're
are
telling
telling
they're sending the message that the legislature, this is maybe something the legislature has to deal with. Historical development, if that's what you're telling me.
And it may be, but that doesn't save the statute as it is now, and it doesn't save the statute that Mr. Nichols and Mr. Jackson were indicted under. And you can't tell me that we're going to rely on dicta in a Supreme Court case, because the Supreme Court specifically has already said you can't rely on our dicta, and that's Weaver versus Massachusetts at 137 Supreme Court, 1899. So let's move from dicta to the reality of the test. The reality of the test is Mr. Nichols and Mr. Stillwell and anybody else in here are members of the people, just like the members of the people for purposes of the Fourth Amendment. You know, he's been convicted of a felony, but he can still say, because the right of the people to be secure in their personal papers from an unreasonable search and seizure, if the people meant felons couldn't be protected by the Fourth Amendment, the people is a status that's not included in either one of those provisions. So I guess the Fourth Amendment would not apply to any convicted felon either. I guess what I'm saying is, based upon the record and based upon the lack of record and proof from the state, I think that the state has not carried the burden and that these statutes are unconstitutional.
All right, thank you, sir.
Oh, all right. That was interesting and way left field or right field or whatever. It was interesting, but yeah, but we have today's hearing to attend to. That was really interesting. Yeah. I tweeted out to Ian and Branka that they should listen to the first 25 minutes of that hearing. Oi, oi, oi. But we are here for this, today's hearing, and nothing else.
Thanks, Sergeant Ingram. Okay, Ms. Love, are you ready? And you, Mr. Uhelski, ready?
Your Honor, I believe that I was seeking enlightenment as to which BB and Eppinger phone extraction was served in Discovery 13. The only one that I'm aware of is an Eppinger phone extraction that was served prior to Discovery 13. So if we could get some enlightenment as to which Eppinger and BB phone extractions were served in 13.
They said January 13, 2023.
Oh, they said that they were served on January 13th?
No, that's from January 13th of 2023.
There is no Eppinger and BB phone extraction in Discovery 13. So I've asked during the break, it's shown where that is.
Okay, do we know how many Twitter,
I do. I can share that on the screen for the court. It's a very small number. I downloaded it in about 2 seconds.
is that
And-
from 2011?
Yes, those are the ones. The millions, I can show the court.
Well, that would have been from 2014 to 2021.
All of them, every one of them that we have that were served in 2013, I can show the court.
Okay.
That wasn't what you.
Let's get to your argument and we can kind of go backwards if we need to.
Yes, ma'am.
That, like,
Your Honor,
that 2013, I mean, yeah, I suppose you can download it in seconds. But, I mean, with good enough internet, you can download a crap ton of information in seconds. So that doesn't say much. And if that is just the Twitter history, one thing. But if it is the data behind it as well, now we're into a different kind of animal. I think she's trying to pull a fast one on the court here.
I tendered to the court for the court's review a document I labeled State's Exhibit 1. It's a Discovery 13 audit that we have provided to the defense previously. As part of Discovery 13.
Okay.
As part of Discovery 13. Wording is important here. I'm smelling a rat here.
And Your Honor, I will start off by pointing out that the court is well aware of the progression of this particular case, who was assigned to it, and what has transpired during that time. Judge, we
started out with your former colleague, Mr. Geary, and I want to say Mr. Smith.
that is correct.
And then I want to say as well, Ms. Rosenwasser. And that was through the summer of 2022.
Thank you. That is correct, Your Honor.
And I do believe, and I want to say that from our, before you and Ms. Hilton were involved with this particular matter, it looks like that even like on May the 23rd of 2022, Ms. Weaver was kind enough to look in our other record, the record from that date, I should say. And the questioning comes up about this discovery, and it's meted out at that point in time by Mr. Farley, Mr. Menendez, who represented Mr. Farley. The colloquy goes as follows. The court, unless you have anything else, you may be excused. Mr. Farley, you may be excused as well. Mr. Menendez, what's the best way to get to discovery is the question I have for the state, so I can drop off a USB or whatever they want to do that. The court, Mr. Geary, do you want to answer that? Mr. Geary, Judge, I'll address that at a later time. We're trying to put these cases on one. Right now, I'm anticipating at least a 5 terabyte drive to put all the discovery on. I'm not at the point to confirm. It's just that it's just yet, but we will soon, Judge. Mr. Menendez, yes, Your Honor, thank you. The court, unless you have any other business, you may be excused. Then from the record of June the 2nd of 2023, Mr. Steele, Your Honor, along with the Honorable Avis Hornsby and the Honorable Keith Adams, we'll be ready for our trial. We understand the enormity. We only have 2 cases for this type of discovery, and I'm being told it's 5 terabytes would fill up the entire hallway of the 8th floor of the Fulton County Courthouse or more. We can't get through discovery, so what we did in other cases, we had a search engine company we already spoke with. I believe I asked Mr. Geary. He's been telling me he'll get it to me, no problem. He's an honorable person always, and we're going to get through discovery. It's like searching Lexus. We're not going to be able to read everything. Nobody's going to read, able to read all that, but we'll do our search terms, and we are with the court on the 9th day of January 2023. If that gets bumped, because I understand there are a lot of people here, the court may say, I want to sever. Some people ask for a continuance that's granted. That's why I filed a demand for speedy trial. I understand, and we'll file it once it's good with Judge Brasher's order, but I wanted to be upfront with everybody and give everybody notice that's our intent. So, and then Mr. Steele has a couple of letters, which I'll include as part of the record in this case, and they're from dated June the 8th, which he's delivering, he says earlier, is his proffer. Dear Mr. Geary, along this letter, we are tendering 2 8-terabyte drives, which based on your representation to me should be sufficient size for discovery to be loaded on same in the above aforementioned case. Please advise how long it will take to load the data on those drives. Please also notify me as soon as the copying of the discovery has been completed so we may retrieve the files. And then on the 16th of June, Mr. Steele again follows another letter with Mr. Geary, and he says, as known on Wednesday, June 8th, 22, pursuant to your direction, my coworker, law clerk Law, appeared to your office with an 8-terabyte drive to obtain all discovery in Mr. Williams' case. He directed me to do the same. However, law clerk Law was told by one of your coworkers that you would not accept this hard drive because you would place all discovery on Dropbox. Please note that I'm being told the Dropbox platform would not be searchable and thus would not be a proper way to handle this massive discovery. I need discovery in the way that you originally told me it would be provided, which would be searchable on a hard drive, and the same would have each piece of evidence that belongs, according to the prosecution, in each count of the indictment and each overt act on the RICO charge.
All I'm hearing here is for months and months and months and months, the prosecution avoids handing over discovery. It's either to, if we have to make it searchable on a 5-terabyte hard drive, then it's up to an 8-terabyte hard drive. And then, no, we are going to do it on a Dropbox and make it searchable. I mean, these are spanning 6 months of the prosecution refusing to hand over discovery because, oh, we need to do it searchable. Oh, it's not good with hard drives. Oh, this, oh, that. This is the prosecution avoiding to hand over discovery. And they still try to avoid handing over discovery until the last freaking minute.
That was very organized, and I would appreciate you allowing me to have discovery in that manner. And pleasantries are considered, but I'll mark that as court one. So it seems like we've started this discovery travel starting in the summer, in particular May when the original case was indicted, and then June when your other parties were managing this case, and then we had some discussion about the discovery commencing at that point in time. That's why thus the terabyte drives at that point in time. So I guess my concern, just since I've shepherded this case from its inception of indictment, is that discoveries kind of come in. First, it was promised up front. It was changed. The parameters were changed. And then, we've had these basically disclosures over the course of 12 tranches of discovery materials. So, I mean, in order for the defense to get ready for this trial, there's a lot of legwork that needs to be done. And, I think part of their challenge and their frustration and the court's frustration is I need to make sure that everybody gets a fair trial and that it would appear that looking at and the reading of 1716.3, which is copy of the indictment or accusation, list of witnesses needs to be furnished, within the 10-day period. Then 17-16-8, list of witnesses and the requirements therein to include home address, or better yet, hold on. The names, current locations, dates of birth, and telephone numbers of the parties' witnesses, unless for good cause the judge allows exceptions to requirement. So, and then so A, B, and C of 17, 16, 8 basically tells what you're supposed to, disclose. And then 17, 16, 6 gives the court discretion for failure to comply with discovery requirements. So, the defense has basically said, they're put at odds because of the manner that this discovery came out, the way in which it's kind of been put out, and the like. So I guess my first question is, why didn't you just give them the 5 terabyte dump at that point in time? Because part of the concern that they're having is, well, we could have been spending this 10 months kind of just chasing down whatever else we did. I'll deal with the witness list a little later, but.
So yes, Your Honor.
Can you answer for me that to begin with?
As it relates to why the team chose to use a Dropbox medium versus the 5 terabyte medium, I can only assume that because of the length of time, perhaps, that it would have taken to upload it to Dropbox, that they thought that, or versus uploading it to a hard medium.
But they changed the method.
They could have been concerned about the dissemination as the
Blah, 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 blah. We don't want to. We want to prosecute him without defense having a fair trial. Please, Judge. That's what I'm hearing here. What a load of... She's pulling a fast one on the court.
court is aware that once we provided, this current team provided the defense with a hard medium. The very first time that we did, there was a video that was leaked. There were threats that were made upon a witness's life. I don't know how that happened, but that happened the moment that we provided a hard medium of discovery. But, Your Honor, that effort at providing discovery in no way rises to the level of bad faith asserted by Mr. Steele and Mr. Williams. Here, the state, I have heard Mr. Steele assert many times that Mr. Geary is ready to testify, in making certain that I have the information available for the court. I spoke with Mr. Geary, and he did not make the representations that Mr. Steele proffers to the court that he made. And he said that he would be available to come and speak to the court if the court so desired to hear from him.
I'm not going to cast aspersions on Mr. Geary's office of the court, but I do have some transcript references from May the 23rd, from Mr. Menez and Mr. Farley.
Right.
And from June the 2nd from Mr. Steele, asking or following up on this issue with the discovery. And I also have some letter from Mr. Steele on the 8th and the 16th of June. So, and I recall this conversation that Mr. Geary had saying that, hey, okay, and this further substantiates that there was, or the state was in possession of a large tranche of materials, because we wouldn't have had the conversation at that point in time in June, come over and give a 5 terabyte drive or 2 4 terabyte drives, and let's go ahead and do that. So why was that not done at that point in time is my question to you.
I can speak to the length of time that it takes us to transfer data via the fastest mediums that we have. And given the fact that it would have taken...
These are nonsense answers. Nonsense answers. she's up there doing everything but outright lie to the judge that she doesn't want to. She doesn't want a fair trial, in my opinion.
In days, weeks even, for us to upload 5 terabytes of data onto a medium that we had previously.
But we had the opportunity to do that in May and June of last year. And if that were, I mean, I remember you told me that later.
That was with the faster drives.
That was with a later, but still, you could have done that over the course of a month in June or July of last year.
So is the question to the
Yeah. May or June of last year, 2022. Here we are, over a year later, and they still haven't produced the discovery, all of the discovery. Still.
state why it is that we chose to use Dropbox versus.
No. You can forget the Dropbox issue, because the Dropbox, I already know that was already maintained, that was not a secure way to maintain the files. And in fact, you told me we couldn't do it that way. But I want you to go back to the original question of why. If you don't know, then just say you don't know. But why didn't you put the discovery on a drive? Because it'd be one thing if we said, hey, Your Honor, we have gotten with Mr. Steele and Mr. Harvey, and we've given them their terabyte drives. Mr. Botts, on the other hand, has not come by yet. He didn't come by till September, October. That's not the, and I'm sorry I'm picking on you, Mr. Botts, and it was your birthday yesterday, but you'll get over it, okay?
Happy birthday.
But anyways, but that was not what happened in this particular case. That, from the state, John Geary, Ms. Rosenwasser, Mr. Smith's representation at that point in time, that in particular, Mr. Geary, they were going to go ahead and transfer this onto a disk or onto a drive. And why that never occurred, that's the first question I want you to answer for me.
I believe that it was logistics, but I will confirm with Mr. Smith since he is still with the team. And I would, if the court permits me to come back to that in about 3 minutes at most, I can probably do it that way.
So that's my first inquiry. Second inquiry is, why did it take so long to get the discovery to the defense if you all claim you're ready to go?
Your Honor, that was the representation that was made by Mr. Steele, the 97% done. I don't know.
I want to talk about that, okay? I don't think that's relevant. I mean, what I want to find out is, why didn't you all give, or what steps did you take to preside, to make sure that most of your discovery was in fact tendered?
Your Honor, what we found is that we did take great steps to make sure that it was tendered. And we learned that as the new team came in the latter part of September of 2022, and we ended up serving discovery that we did not even realize had been previously served. And by serving discovery, I mean hundreds of gigabytes. So the data that they received when they began complaining, and for instance, Discovery 12 was the new team trying to ensure that the defense had all of the acts, all of the information. As we went back and went through these gigabytes of data, we wanted to ensure that the defense had everything that we might possibly use. So we ended up serving probably about 2 terabytes of duplicate discovery. We have an audit for 13. We did an audit of 12. I personally was one of the people who put together 12. I literally began amassing files, digital files. The previous team used physical files, and they were copying information and disks from physical files. I had access to digital files that I was not aware or certain that the previous team had access to. So when I started looking at this case, I began pulling data from digital files. I began pulling data that had information that was not relevant to a particular act or to a particular case. And it had information such as perhaps hospital records, social security numbers.
Yeah, this is word diarrhea at this point. This is so infuriating. This is her, we don't wanna, but she's wrapping it in a lot of words that says absolutely nothing. And the judge specifically asked her, specifically,
things of that nature that had to be redacted before it was served. So that was my own personal effort, along with other members of our team, pulling data digitally from different sources, not even realizing, having come to the team more recently than other members, that we had already provided much of that discovery in the first service of discovery back in July of 2022. So I can say with certainty to the court that the court has seen an exercise of the very best efforts on the part of this team to make certain that the defense is provided with any and everything that we do intend to use. The fact that it was provided over time in different discovery links, I would not call that drips or drabs or tranches, Your Honor. I would say that we have given to them discovery that has been delineated the way that it was represented it would be delineated, by act, by count, in the way that they have requested, the way that it was done. That's literally how the first 9, 10, 11 discoveries, even through 12 and 13, were given to them.
And then why wasn't it ready in July or August?
That wasn't.
Why wasn't discovery? I mean, if you had access to all this stuff and access to formulating it, why didn't you just assemble it all together earlier, like in the early fall, when you and Ms. Hilton and Ms. Uhelski and others came in at that point in time?
Your Honor, as we get ready for the case and as we get ready for trial, I'm certain the court is aware that, different people think different things are relevant and pertinent and would seek to perhaps find value in places other prosecutors didn't. But what we did do was we began reading the file as we were assigned to the case. We began evaluating the file. There's a count 1 on this indictment that consists of 191 acts. And overt acts, as to count 1, include having been here as long as I have, I was aware of cases that I was not certain that the previous team was aware of. And I researched and reviewed files and pulled files and requested data, information that I wanted to make certain was included as a part of discovery that, again, I did not even realize had been previously served via duplication of a physical file. So these were ongoing efforts because we do have an ongoing duty to provide discovery. It doesn't stop. It does not stop. And as we receive, as we review information that is pertinent to the case, whether it's good or bad, inculpatory or exculpatory, we turn it over. That's what we've been doing. And that's what we will continue to do. And what Mr. Steele has...
What do you mean continue to do? It's 11 days till the first day of trial. What do you mean continue to do? They should have had all of this months ago. Months ago. And here you are in court 11 days before trial, day 1 of actual trial, and argues you have still not released everything.
Failed to show, or anybody has failed to show, is an act of bad faith on the part of this prosecution team. There is an utter absence of bad faith on our part, Your Honor. And I would point to the State versus Bryant, which is 307 Georgia 850 at 854. Just before the Georgia Supreme Court vacated and remanded a case to the trial court, the court noted that the trial court said it found the result of bad faith exercise in failing to provide discovery. On the other hand, the trial court also stated in a footnote that it did not find any ill will nor deliberate action perpetrated by any particular state representative or the state per se, but persistent failure to comply with an ordered process without justifiable explanation. The Supreme Court said these two findings appear contradictory. The latter statement appears to reflect a finding of mere negligence on the part of the state, and the court said that if the persistent failure to comply with an ordered...
Now she is moving into, it seems like she's moving into argue, please don't punish us, judge, territory.
Process without justifiable explanation is deliberate, that failure to comply may constitute bad faith. But if the failure to comply is simply due to things resulting from staff turnover, that failure in some circumstances is not bad faith. And that bad faith that is required to impose a sanction of exclusion. Here, Your Honor, that is what we have had. We've had a staff turnover of sorts and a persistent and continued effort on the part of the prosecution team.
That's not the defense problem. You are trying to make a you problem into the defense problem. You having turnover of employees and new prosecutors on the case, that's not the defense problem. That's a you problem. Jesus Christ.
To provide the defendant with the discovery available in this case. I know that prior to our coming to the team that there was an order issued. We were concerned with respect to information on our witnesses and the safety of those names and the security of those persons. The court had entered an order prior to our coming on, but we wanted to make certain that we provided, as we gained access to that information, all available discovery. And I have not one instance heard any assertion by any party, any person that points to any act that even slightly hints at deliberate ill will or an intention to keep anything from the defendant.
You just said a few minutes ago, continue to deliver. That, for me, says you still haven't provided the defense with all of the discovery. You should have turned over in May of last year. Oh.
In order to put them in some kind of a bad position.
Okay, I'm the defense, okay, in this case, and I've been getting discovery all along. It's after September the 8th of 2023. The case commenced in May of 2022. On October 5th, I get more discovery, and some of that discovery involves the things that Mr. Steele Mr. Steele kind of complains about, and I have 308 new witnesses. So how am I supposed to get ready for trial knowing that, not knowing whether or not some of these witnesses are duplicative of other witnesses that have been previously provided in the other 12 discovery disclosures, and these particular new, I need to kind of get granularity on the phone dumps and the social media pages, how many there are. But, and Instagram pages or Instagram records from 2014 to 2021 of Mr. Williams.
I can show the court that. I can show the court what that is, that Mr.
In terms of what can you show me?
The Instagram records and the social media records. I can pull it up for the court and show the court what is complained of. I just need the Zoom link. I'm going to pull it up.
I mean, and earlier she said part of Discovery 13. So, I mean, yeah, you could probably download, if you have good internet connection, you could download a Twitter, whatever it's called, even years of it in a matter of seconds. You probably could, but that's not the issue. The issue is that's just the raw data. Numbers. Now, every tweet has its own data applied on it. And getting through that is a gigantic task for the defense. Because they don't know what the prosecution is going to show. I mean, say it's 100,000 tweets, and they have selected 10 of them, and the defense doesn't know it until she produces it. That's not fairness.
And I've also received word from Mr. Smith that Mr. Geary's reason for sending and using Dropbox was a method to keep track of when discovery was received and opened by the defense so that we could keep a record of when it was.
That doesn't help me.
Okay.
That doesn't help.
What? So your reason for wanting to use Dropbox was that you could see what and when they opened certain files. That's not up to you, prosecutor, in my opinion. That is trying to predict the defense strategy. Because when you search for different things through Dropbox, you have a word, or 2 words, or a line of words, whatever. And those are the ones you open first. Now the prosecution will know, oh, that's most important to them. Ooh, that's, in my opinion, that's really bad. That's really, really bad.
That because regardless of whether or not, even though that may be true, and I'm not saying it's not, it still doesn't explain why then you just didn't put it on the terabyte drives and give it to them. I mean, we're always going to have some issues with disclosure, despite the fact that the court signed an order to the contrary. But that doesn't excuse the fact that, as you mentioned earlier, that discovery should have been tendered already. Because it sounds like from my conversations or the court's collective conversation with Mr. Geary and Ms. Smith was that a large chunk of that discovery is ready to go. And they need to provide those terabytes so they could get it. All right, so I see your file enumeration, social media.
I don't trust
That is one of the files.
what
Is it a YouTube video?
Yes.
Is that it? Does it have any other?
Nope, Your Honor. We're going back. Twitter. I'm clicking on Jeffrey Williams. These are the millions of files.
Those are the tweets. It's so there's probably looks like.
I can open them up. I can start with the largest one.
I'm just counting how many there are. 16 tweets thereabouts.
PDFs that have individual tweets in
I open
them.
up one.
You sneaky son of a bitch. You chose different files. 16 tweets. Yeah, that might be a Twitter discussion. That's not the dump. That's not the dump. That's not the Twitter dump. That is you selecting part of his entire Twitter feed or Twitter history. You sneaky.
Okay.
Open up number one.
Here's one. This is the largest one that we have.
Okay.
And
That's Slat from Young Thug. Okay.
Yes.
All right.
these are, you can see that a lot of it is blank pages, but,
You need to open it. I haven't seen it yet.
okay. And the other ones are very similar, Your Honor.
Can I see it?
Yeah.
You said you're gonna open it, so let me see. Let me see that file.
Oh, it's not showing. Okay, I'm sorry.
No, it's not. You gotta, I think you gotta close it. And
You do, yes. Okay, and you can,
Oh yeah, I remember about those terabytes, and she actually asked the court that the defense buys the terabyte disks or drives, the terabyte hard drives, so they could swap because she didn't want the expense on her. The state has more or less unlimited resources, and she wanted the defense to pay for the hard drives. She's very selective in what she's showing the court. This. Yeah. Shady lady. Yeah, and that, oh, yeah. That is Fanny Love, the prosecutor who is indicting former President Trump. This is her in action. This is what she does to win a case.
This is the largest Twitter file that we have.
So now she's showing individual tweets. That's not a Twitter dump. That's not a Twitter data dump. You sneaky son of...
Many of the pages in that particular one are blank. I'm going to stop that screen share, and I'm going to open up another Twitter file. This one contains 2011 and 2016 tweets. I will share that with the court.
Why does she have the 2011 and 2016 in the same file? Why? 2011 and 2016. Why is that together in one separate file?
And the court can see, I'm just going to scroll down. It won't take very long at all. The end of the scroll is right about here. And the other PDFs are similar in nature to the two files that I just opened up for the court. I can open up all of them, or I can provide the court a medium and let the court open them up at a different time.
It seems like all right, I now see what you're talking about. Okay, so.
And I can go back. Those are the PDF tweets. These are individual ones. There's a countable number. I'll share this screen with the court.
Please, defense, have one really tech-savvy person. Please.
And what are these?
These are individual tweets. I can pull up one.
I don't think she's showing the court the actual Twitter dump. I think she's actually showing parts of.
These are, rather than being pages that have the multiple tweets in them, these are individual tweets, such as the one on the screen now.
Okay.
So those that I have shown to the court that are here, they contain one tweet per PDF.
All right, so how many PDF files do you have at this point in time?
How many are there?
Okay.
Why would you separate each tweet into a separate PDF? That's not the discovery is the data dump, not how you choose to organize it. Not how you choose to put 2011 and 2016 together in one file, and then all of a sudden here you have a separate tweet in separate files. I mean, this is so sleazy.
So you got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11.
44 selected
44
items.
items. Okay.
Yes.
All right.
And
Is that from the period of time that you are planning to introduce?
yes,
Okay. What is that representative of? What period of time?
that goes from 2011 through 2021.
That's not discovery. The discovery is all of it, not what you choose, what you say now you plan to enter us into the trial. Now, you still have to do that so that the defense has time to, but they still need all of it so they can see, okay, what happened before and after to put context into what you are trying to. This is beyond sleazy.
Okay. All right.
Also, Your Honor, as it relates to Jeffrey Williams. As far as Instagram is concerned, we have this photograph. That's the Instagram file.
I don't give a flaming fuck about separate Instagram photos. If you sent over the dumps, that means all the photos, not the ones that you now choose to present to the court. What is the discovery you sent? Not what you chose to see. Let us watch now.
As it relates to other items that are in Discovery 13. I'm unaware of where millions of documents are as they relate to social media for Mr. Williams.
Yeah, that's because they are talking about what you dumped in their lap, not what you now choose to show the court. Two separate things. I hope the defense is prepared for this.
Can I help, Your Honor?
Yeah, are there any other ones on this file that you're talking about, Mr. Steele?
If Ms. Love would please go to the file named Other YSL Information. There's a subfolder, search warrants and returns. There's a subfolder, Jeffrey Williams. And Ms. Love can share the screen.
I sure will. On the screen is Jeffrey Williams' Instagram return.
And there are some 2,842 positive responses.
Pages. They have information such as what the court is looking at now.
I don't know where they found all of these. And on the one file he asked her to open, it's over 30,000. That's one of the dumps. This is her misleading the court.
And scroll down just to get to
This is source information you're talking about.
Yes.
Okay, all right, and there's some, so the last thing I saw was 532.
yes, I can go back there.
Can you go back to that?
Yes.
And those are the pages.
That's at page 532. I'll just
So how many
scroll
pages
down.
of identification data do you have? Like from when does after the identification location data, when do you have pictures or any other things that?
Judge, there are other files in the folder. What we can do is go through those folders and look at those folders and those files.
All these have pictures, and if you look at the file in the same area of returns, you will see 10.7 gigabytes. That is, I'm told by Surrey, it's also Google. That's 200,000 PDF pages is 1 gigabyte, so that's more than 2 million PDF pages. It's in the same area of the returns.
And so if Mr. Steele would just give me the file name that he's referring to, I can pull it up and let the court see it. I can share it.
Returns.
The return has several file names. All I need is a number.
Jeffrey Williams.
The return had several file numbers, and he was just referencing one with over 200,000 entries. And there's more than one.
All I need is a number. Just give me the number. Which one?
Oh, all of these. Well, look at, all of these are the
You do realize that
Instagram.
this is a compressed version of that. So which one? There's an after that. Which one?
Try
Compressed versions? Oh, you.
That one.
Sure. This was the compressed version?
Did you show the screen?
Yeah, I was waiting on it to come up.
She made it sound like it was just a few dozens, a few hundred maybe, tops. And we are
Here
already.
is the screen. The registered email address is slatseason@gmail.com. Thugger1.
She is so.
I have pulled up the. Here we go.
Okay, let's see, starting, okay, keep-
Got it, every blue line is another messaging picture, every single one.
after, starting at 5401 or
No, it starts earlier.
now, I mean, some of the file is identification data. So when do the actual pictures start from this particular file of, it's 26,118.
The identification data is part of the discovery. You just don't just look at the pictures. The pictures comes with the data attached to it. It's all. Oh God, no, Judge! Don't focus on just the pictures. Ah.
I'm looking at the number of pages. So when does the picture start in this file? I mean, I know you got a lot of identification data, but
If you take a picture, a minute to load, but every blue line is a spark, it's a new picture, and all the things you see right here is just like comments on the picture. But you just could load.
And now Young Thug speaks out because he knows more than the defense lawyer and the prosecutor and the.
So, Your Honor, I will go back up to the very beginning and just take it page by page. Slowly.
Well, those pages are blank.
If you say 26 hours, that's on the photos.
And Your Honor, I'm just scrolling slowly so that if there is a photo on the page, it has time to load.
About 127,000 for
Can you open the one?
Whichever folder counsel would like me to open and share, I can do that. If they give me the number, I will open that one up and share it with the court.
Can you go to John's list of files
Yes.
and show that?
Oh, wait, that's not it.
Can you go to folder 12205, I'm sorry, 5, 1220455, 45,
G-
157, 43.
Gigi, you have pneumonia. We can handle it. I can handle it. Go. If you need rest, take rest. Thank you for coming here. Bye-bye. Everybody say bye to Gigi, my first and best moderator. Yeah, take care, Gigi.
It says it's 1,600,000.
I just clicked it and I'll stop sharing this screen for return so that I can share the particular file counsel for Mr.
1,600,000 entries in one file that the prosecution tried to avoid telling the court about. 1,600,000 in one file.
Williams requested.
That's 1.6 million kilobytes now.
Are you opening it?
Yes, Your Honor.
I think
It's, it's loading, but it's not showing.
And I mean, we're close to 2 million entries in just a few files. 2 million entries that she put in their lap a month before the trial.
I have 127,600 pages. 127,603 pages.
Another 127,000 in another file. Yeah.
And that is about 1.6 gigabytes of data that counsel or representative for Mr. Williams is referring to.
Okay, so how many pictures?
And a movie is like,
How many pictures does that represent?
how many
I want
individuals?
to see the folder. So.
Okay.
Pictures has nothing to do with it. Damn it, Judge. It's not about the pictures, it's all the data about the pictures as well. Mother.
Put it on a terabyte drive. Okay. We ask them if they'll bring the terabyte drive that has the
How
discovery
is
on it over
this
so that we
not
can just
bad
load that up
faith?
rather than trying to go from the server.
How is this not bad faith? She pretended to report it was just a few hundred.
Your Honor, I'm pulling this up from our server, and our server is slow, so I'm asking that counsel bring over the terabyte drive that has the discovery on it so that I can load that quickly.
She has everything on a terabyte. She has it? Oh, crap.
If the court will permit me to pull that up when he gets back with that, or when he's able to get a member of our team over here so that we can pull that up for the court.
All right.
Yeah, no.
Additionally, Your Honor, these are returns for the social media pages of Mr. Williams. They are, obviously, they are not items unknown to Mr. Williams. They are items that the state.
Oh, no, you don't. You don't blame the defense. This is your discovery. You are supposed. The defense has no obligation to prove anything. Oh, you. Oh.
Has secured in order to utilize as evidence in this case, but they were known to Mr. Williams and anyone else.
When were the records available, or when were the records procured? Were they procured back in January of 2023, or when did you all get the records from? From the social media providers.
So in order to prevent Your Honor, there is an order to produce Jeffrey Williams' Instagram from 2014 to 2021, signed by a judge on December 30th, 2021.
And when was it actually tendered by Instagram?
So it was,
They've had it since 2021. Okay, Fondin, Georgia doesn't have to turn anything over. Yeah, that depends on the trial. This is a RICO trial. I think that it is all about the motion to discovery. And since this is such a huge case, I do believe that that particular rule is. But this is why they have had hearings about sending over discovery to the defense since May of 2022, a year and a half ago. Just because this is a RICO case and it's enormous. So they might have applied that rule in other ways in this case. Thank you, Fondian. I appreciate you being here.
search warrant was December 12th.
When did Instagram send?
I'm looking for that.
When did they finally, answer that request? Or
I'm looking for that, Your Honor. Search warrant. Returns inventory.
bless you.
Ask someone to get the terabyte drive off of my desk. And let me find out.
Yeah, I know.
I'm finding out about the
For a year and a half,
Instagram search records.
they've asked for discovery so that they can interview witnesses, interview potential witnesses, prepare the defense, and on October 5th, everything they are talking about today
And since
landed
they
in the defense lab.
were procured by Investigator Miller, I'm looking to see what date that they were secured. There's a modified date on here, so that looks to be perhaps the date that it came back, of February 7th, 2022. But I can't say that that's the date that we got them back.
This is insane.
And I can say as well, Your Honor, that any information that we have provided has been the result of ongoing efforts to make certain that we've served everything that we have and intend to use.
What you intend to use, it's not...
So if the court would give me about 10 minutes to go check with my colleagues and to get this particular file, or I can wait until they're able to bring that over with that information and continue on. But to answer the court's questions, I need information from my team.
Yeah, I think you probably should figure out when. I mean, my concern is that if you had the information in the spring of 2022, why didn't you just tender it at that point in time?
Your Honor, I can.
If you tendered the whole thing and then cherry picked out what you wanted to use, then the defense would have been put on notice that, hey, you had this very large file with a bunch of Instagram photos and everything else, but at least it kind of puts everybody on notice that, hey, here's something that you're going to have to kind of look through. Some of it may be exculpatory, some of it may be inculpatory, but getting it now or getting it, in October that's a little bit much.
Oh.
Your Honor, I understand.
Oh.
I mean, you see my
that
concern?
position.
You see my concern that it's from my perspective as a court, there's a great possibility you've had this material for at least the better part of 6 months.
I don't.
That's my concern.
I don't disagree with what the court is saying.
And that's my concern about, Mr. Steele saying, hey, given the voluminous nature of this file, that's a lot. That's a lot for anybody to have to go through.
Your Honor, I don't disagree with the assessment that it is a lot that anyone has to go through. Certainly, it's a lot that the state has to go through, and it wasn't a matter of holding back. I'm not disputing anything. What I'm saying to the court is that we have files in multiple different places digitally. I personally have attempted, Ms. Hilton, Mr. Uhelski, every person on this team has attempted to make certain that we have gathered through the universe.
Yeah. Another thing. The state said they were ready for trial over a year ago. And they are still producing discovery. They are still investigating. They said they were ready for trial to begin January of this year. Here we are, mid-November. Hey, Dave. Good to see you.
Of our data, the information that we intend to use in this case. If there were instances where information was not served, we have gone back and asked, was this served? In some instances, we thought stuff was served. It wasn't. We served it. And in some instances, we did not realize that it had been served, and we served duplicates. That's the ongoing effort.
Okay, this file doesn't look like it's a dupe. That's the problem.
Your Honor, I didn't hear the court.
This file doesn't look like it's a duplicate.
It doesn't appear to be a duplicate, Your Honor, and I'm not disputing that. What I'm saying is that at no time did the state or any member of this team attempt to not provide to the defense information that we intended to use in this case. We have been getting information from different sources. We have been communicating with different investigators that have been on the team who are in different areas of, the office or in other offices altogether to make certain that anyone who had information pertinent to this case, and there were multiple investigators working on this case. Some of them are no longer with our office. We have reached out to them. We have tried to make certain that everything that we have on this case is provided to the defense. And Your Honor, the reason that I have a problem with the idea that we are acting in bad faith or that we are trying to withhold.
You're either acting in bad faith because you're conscious about what's going on, or you're a fucking imbecile. It's one of the two. Either you're doing this on purpose, or you're a moron.
Information, or that the court should exclude the defendant's social media accounts is that, one, if more time is needed to go through the social media accounts, more time could be allotted by the court. What we are asking is that the court does not employ the extreme remedy of exclusion of relevant, pertinent information on the basis of it's an inconvenience to go through. I don't dispute, I'm not arguing.
That's more than an inconvenience, Ms. Lowe. That's a Herculean task to go through if it's as many photos and files as I think it is. But I'll pause on that until you can load that thing up and show it to me. But let's turn and talk a little bit about this witness list. Okay?
Yes, Your Honor.
What is the current witness list for the state? How many witnesses do you have?
Your Honor, we have provided that to the court and to the defense. And we have not only provided that, we have included on that witness list
He asked for a number.
Index that points to which case that they will be used for. We have provided phone numbers, addresses, email addresses, alternate phone numbers. We have provided everything that we can get our hands on as it relates to each witness that we've provided the name for on our list.
Okay, so how many, I'll go back to the original question. So how many witnesses do you have on your witness list at this point in time?
Would you pull up our witness list, please?
Can you give me a number?
I will, Your Honor. I'll pull that up.
And while you're thinking about that, I also want to know, well, first get me that number and then I'll ask my next question.
Yes, Your Honor.
He knows exactly how many witnesses is on her list.
258 lay witnesses, Your Honor.
So it's 258 lay witnesses.
Yes, and 479 professional witnesses.
All right.
$258 plus 479. 504 witnesses. Out of those, apparently, according to the defense, I don't think that's included, the 300. I don't know. Yeah. Judge is not happy. But will he bite and not just bark? Yeah, exactly. She stated she wanted to see what files the defense accessed. That was via the Dropbox thing. She said that in open court so that we could see what files they opened and accessed. That's horrible. That's none of your fucking business, prosecutor, which file they open or not open. None of your fucking business. Well, he can issue fines. He can throw that piece of evidence out. Hey, legal vices. Hey. This clusterfuck of a trial is getting more of a clusterfuck for each day. Thank you so much for your super chat. Sweet talk for life. Live long in prosperity. I don't know. This case is going to give me a heart attack. No, it won't. My heart's in good health.
Will the court permit me to take my seat at the table so that I can pull up the files from the drive that I'm holding in my hand?
Yes, ma'am.
Thank you. Can you get this? Ben, can you grab this thing?
Okay. How many, this is the current witness list as of now. 258 in terms of lay witnesses, 479 in terms of professional witnesses. Is that correct?
Yes, Your Honor.
How many witnesses did you have before September the 8th of 2023?
On an itemized list, Your Honor?
Yeah,
Because
Mr. Steele, the last service of your witness list as of September, I should say, as of the October 13th, you had, that's when it was represented that there was nearly 700 witnesses, a little over 700 witnesses. So between September the 8th and October the 13th, what did the witness list expand by?
She just... Oh, 257. Yeah, that's 700.
Mr. Steele told me the original witness list had 36 on it. That was from December the 8th of 2022. Wow.
She has a witness list of 700. What? Fuck. Sorry. 736 people as of now.
Went to some 47 as of 3 January 2023. Then it went through to 179 as of 23 March of 2023. So what was it in September the 8th of 2023? How many witnesses did you have at that point? I mean, I can.
This is so amazingly horrible. But not in a good way. 736 witnesses. 736 witnesses. Okay.
witnesses did you have, what did the witness list grow to on September the 8th of 2023? How many witnesses did you have at that point in time?
Okay.
Because it looks like from March of 2023, you had about 179 witnesses at that point in time. Then in September, you had another increase in witnesses, and the last increase was the one that was about 300 in nature. I think if the court's memory is correct or somewhere around there, you had a little over 400 witnesses in September, about 437 or something like that. And then it appears that Mr. Steele and the defendants, when the last witness list came out, I want to say 13 October, that's the one that had.
Jeff, your F8 Friday starts in 20 hours. You're starting at 3 p.m. my time, and I will be back from work around 4 p.m. So I will. No, it says 20 hours, not 22 hours. No, it says 3 p.m. Swedish time. That's 2 p.m. UK. You got your hours wrong. And by the way, everybody join Legal Voices tomorrow in 20, 21, or 22 hours for F8 Friday. But before that, unload your spare change at least on this poor guy. $3 a month gets you. Oh, hold on. Wait. What time is it? What time is it? It is. It is grifting time. First of all, viewers. Second of all, subscribe. Third, become a member. $3 a month, and you will get the person on LawTube with the absolute most members-only content. I deliver shorts, videos, and streams all the time. I didn't know that was in excess of everybody else on LawTube until somebody pointed it out. And had I known, I might have produced less. But here we are for just $3 a month as a member. And the occasional super chat, always appreciated, as you love me, don't you? All right. Yeah. That's it. Yeah, and if you don't want to support YouTube, getting 30 or 40% of it, you can go to PayPal. And Ghostery just posted the link to my PayPal. They only take a 5% cut. So, yeah. Okay. Back to the stream. Thank you. There. Oop.
Had the 700, a little over 700 witnesses, and to your count, 737. Because we had a discussion at that point in time about the witness list and whether or not Mr. Steele apparently asked me at that point in time, well, then at least run the GCICs on lay witnesses. We had that conversation about, the statutory power and the power that the state would have. So I remember that from that particular time period. So my question at this point in time is the 737
okay, 737
inclusive or exclusive of duplications? Meaning that are those the universe of people that could be subject to being called in this case? The 737?
Oh, God.
Yes, those are subject to being called in this case. When the court asks whether they are inclusive or exclusive of duplications.
Yeah, do you have are any of those duplications, or is that the known true universe of witnesses that may be called to testify in this case?
I believe it is, Your Honor. I believe it is, and what I'm going to do is pull up the witness list that we sent to the defense on September the 8th so that I can make sure that I'm answering accurately for the court.
Yes, ma'am.
Oh, yeah, Jeff. At around 55 minutes into my stream, the N-word is uttered. Sometimes. And then they had a Second Amendment discussion by quoting a 1792 statute. Sometimes.
So on September 8th, it looks like we had 632 witnesses. If I'm looking at, yes, it looks like we had 632. And then the court asks, what number do we have on a different day?
On October the 13th.
Hey, Nanya. Tomorrow it's the final day of the Dallas, Texas maternity ward shooting. So that's about 2.5 hours that are already promised my viewers, but I will join after that. Okay. Ahead a bit.
Ask you another question, Ms. Hilton. I mean, I should say Ms. Love. How many witnesses of that universe of potential witnesses that you have identified do you realistically think you're going to call? Give me the number of fact witnesses and give me the number of expert witnesses that you have. I mean, your case in chief witnesses.
Your Honor, the case.
Fact and expert.
The case in chief, Your Honor, consists of all of the ones that we've served, and the reason is that the count one consists of 191 acts, and the reason that it
well, you've also some defendants are no longer in this case. So,
right.
Are you still going to present those, or are you going to pare down your indictment, or what are your plans on that?
Our plans have been to pare down the indictment, Your Honor, and we obviously move things around as different things happen. But given that there are overt acts that were committed by people who
The prosecution said they were ready for trial a year ago. So they set the trial to start in January. And here we are in the mid of November, and the trial is starting in 11 days.
may not be at the table that go to show not just the existence of the enterprise, but the current defendant's participation in it, and as well as the pattern of racketeering activity that we allege that they conspired to commit. It's not just, it would be different if it were just one murder or just one aggravated assault or just one burglary on the indictment, Your Honor, but there are a list of acts.
There are 191. Most of them are old cases that was never brought to trial because they didn't have sufficient evidence then. And all of a sudden, let's clump it all together under the Georgia RICO Act and hope that the sheer amount of alleged crimes will be enough for a conviction.
That we seek to show, to introduce as evidence to show the pattern of racketeering activity that they conspired to commit. So, yes, we are still, even now, endeavoring to take out some of these people, and because we want to present the most effective case for the state. And there are some that, there are some of these acts that we feel may not do more than, other acts. And we don't want to lose the jury's attention or anything like that. So we are even now paring down the list. But we have sought, so that there is no confusion and there is no assertion that we did not put someone on notice, we have sought to extract from the discovery that we have provided all of the names of the people that we look to call in this case. we have made great efforts to make sure that we do that, because even though they are listed in discovery, we have attempted to comply with the court's directive that we provide an actual list that has as much information about each witness, including what count they will be called for, on the list. So
It's just word vomiting at this point.
It seems like that if my math is correct, that as of the 8th of September, you had 632 witnesses or thereabouts. And as of the
Oh shit! Enter
current, you got 737.
111.
So since September, we've had at least 105 witnesses. Am I off? Do I disagree?
Your Honor, I would say that the list itself may now include that number of people, but again, these are people that are identified in the information that we've provided, and we sought to extract from that information and make certain that we've listed all of the people that we anticipate using at trial. But, these aren't people that are new to the case or newly made known to the defense.
It
And we
is.
certainly aren't.
You entered 105 in the last month. Completely new witnesses. That's not God.
And haven't attempted to hide any witnesses or anything like that. And I think the last witness list that we served was, I think the court said it's September 26th, not October 13th. That was the date that Mr. Steele filed a witness list. We did not file one on October the 13th. We last filed a witness list 2 months ago.
I don't fucking care. That's 737 witnesses. They, in some shape or form, has to conduct an interview with.
And while we're not asking that anybody make a decision about whether or not to file a speedy demand or forego having an opportunity to properly interview witnesses, Your Honor, we put forth that given that we are making efforts to present and give to the defendants, at least a week out, what witnesses that we intend to call, we would propose that rather than even considering excluding them, that the court simply require that before the state puts particular witnesses on, that the defense be given, that opportunity to interview the witnesses.
But that has to do with their trial strategy as well. You're trying to actively hindering the defense from having a strategy from day one. You ass.
Okay. It's almost 12:30 this one time, and I understand that lunch is available for some, and I am going to recess to allow that to occur. And I have other unrelated business that I need to take up during this particular lunchtime period. So the court, let's make sure.
Okay, so stream is about to end. I'm not sure if they will be back this afternoon, but I think we've seen enough of the defense, of the prosecution's absolute lack of fairness. This,
Let's say we come back for, let's shoot for 2:30. Independency, please find be able to queue up the video file. I want to see that, not video, but the file that, there's two files that are relatively large.
Okay.
I just want to be able to see those. And and then we can take things from there, okay?
Your Honor, may I ask just before we recess an administrative question?
No, I need to take it. So
Okay, that's
what's your
fine.
administrative question?
I just wanted to, in regard to the constitutional, I do have some exhibits. I know Your Honor said they were due by noon. We'll take it after lunch if that's fine.
You can hand them out to the other parties should you choose to do so. Okay? Yeah, go ahead and do that. All right, we're going to be in recess until 2:30.
Oh. Yeah, this, and for you who have followed, I mean, I've been covering this RICO trial for 6 months now, 7 months. And it's always a complete clusterfuck. Everything about that. I don't care how evil or how bad Young Thug is. Not whatsoever. The prosecution's conduct here the judge should have thrown this case out months ago. Months ago. Yeah, but yeah, thank you all for showing up to guide you through this hearing. There will be more hearings next week, I think, on 21 and 22, November 21st and 22nd. And then trial is scheduled to start November 27th. And yeah. Thank you all. I'll see you all later, either here tomorrow on the final day of the maternity ward trial, which will be more or less last witness, closing statements, and whatever comes next. I will be sending you all over to Valhalla Awaits, who is streaming right now, I think, in the Texas versus Caitlin Armstrong, their closing arguments. So I will be sending you all over there to him. Thank you for being here. Thank you for the super chats. Thank you for being members and everything. You all have a nice day. And I'll talk to you later. All right. Bye-bye.